So let's recap where we are. We are in the middle of Unit 3. We'll finish that up this week. I'm going to lecture most of today. Thursday, we'll have a lot of discussion. You have a case that you've been assigned to read for Thursday, the Arrow case. We're going to talk through that. And then I've posted a fact pattern to your content module. I had originally labeled it for class discussion today, but I've changed that to discussion for Thursday. So Thursday, we're going to do the fact pattern and the case. Today, I'll finish up lecturing on courts and litigation, and you will have one quiz for this unit that is due next Monday night. Remember that the quiz covers everything in the materials that have been assigned, not just what I say in class. I'm not able, obviously, to go over every single thing in your outline in class, but you still need to be responsible for that. If nobody has any questions on that, then let's get started. So as a recap from last week, we talked about the court systems, the federal court system, each state court system, how cases can move through those and between those, how cases start out in court systems at the trial court level. They could progress through the systems by appeal if the parties choose to do that. We talked about the idea that a court, in order to issue a decision that's binding on the parties, has to have jurisdiction over the people that are before it and also the subject matter. We talked about how a court could have jurisdiction over people who are residents of another state or a different jurisdiction if those non-residents have done something within the jurisdiction that it's fair enough for them to be sued for. That was the long-arm jurisdiction we talked about. I want to highlight a couple things from last week's lecture before I move to this week's. On the idea of jurisdiction, we talked about personal jurisdiction over people, over parties, but I didn't get into jurisdiction over corporations, over non-humans. So corporations can be sued in 3 different places. Where they're the state where they're incorporated, any state where they have an office or employees, and then in any state where they're doing business. All right, so that's pretty broad. You might have a corporation that is incorporated in the state of Delaware, but they don't do anything else in Delaware. They could be sued in Delaware. That's their home state. If a business is incorporated in Delaware and has stores in Massachusetts and Vermont, they could be sued in Delaware, Massachusetts, or Vermont. If they are incorporated in Delaware, have stores in Massachusetts and Vermont, but they do business nationwide, they can definitely be sued in Delaware, Massachusetts, or Vermont, but also possibly in any of those states where they do business. If they're sued in the states where they do business, then the lawsuit's going to need to be related to them doing business there. Okay? If they're sued in Delaware where they're incorporated, they can be sued for anything there. That's their home state. All right, so that was the idea of jurisdiction over corporations. The idea of standing is something I want you to know. And standing means that in order to file a lawsuit, what do we call the person who files the lawsuit? Y'all are killing me. The plaintiff, right? The plaintiff has to have standing, meaning they have to have some interest in the lawsuit. Their rights have to be affected in some way. My wife could sue me for divorce. She has standing to sue me to end our marriage. Ian cannot sue me for divorce. He doesn't have standing. The dissolution of my marriage has no effect on him. If the state of Colorado passes a law that restricts voting in some way over Colorado residents, I can't sue the state of Colorado saying that that law is unconstitutional because I don't have standing. I don't vote in Colorado. That law doesn't affect me. So you can't just go around suing anybody for anything. You have to have some interest in it. You have to have standing in order to bring a lawsuit. That brings us to today's topic, which is litigation and alternative dispute resolution. So litigation refers to everything that is involved with a lawsuit. All right? Not everything that a lawyer does is litigation. If I go to the law firm and they close on the sale of my house, that's not litigation. That didn't involve a court case. If that's a good example. But in any case where a lawsuit is filed, then we begin the process of litigation. Litigation always begins with the filing of a complaint in the civil sphere. So a complaint is a written document that's sworn to under oath by the plaintiff. It's filed with the court that has jurisdiction. Right? If I go file a complaint with a court that doesn't have jurisdiction, they don't have the power to hear my case. I file it in the correct court. I tell the court who I am, who I'm suing, why I'm suing them, what laws are involved, what they did that violates those laws, and what I want to happen, what I want the outcome to be, what the relief is that I'm seeking. All right, so in an employment discrimination case, let's say that CSU fires me for being Methodist, for my religion. I might file a complaint against them in the local court system or the federal court system. I actually have my choice, but I can't go do it in California, right? CSU is not in California. They're here. I file it here. I'll say, my name is Tom Tebow. I'm the plaintiff. I was an employee of CSU. CSU is the defendant. They are a school that is established by state law in the state of Georgia. They're a member of the University System of Georgia. I was lawfully employed over the course of several months in the years 24 and 25. I was subject to disparaging remarks about my religion, and I believe that I was ultimately fired because of my religion. That violates this law and this law. As a result of that, I lost my job. I've endured pain and suffering, emotional distress. I want CSU to pay for all that. I want my job back. Tell the court all the things that I want. And then I'll file that with the court. The next thing that happens after a complaint gets filed is that complaint has to be served on the defendant. So the clock doesn't start ticking on the defendant until the defendant receives service of process of the complaint. You see this depicted in TV and movies as, somebody handing them the folded up piece of paper. I've seen all that. Service of process is typically handled by sheriff's deputies or by process servers who are appointed and approved by the court. There's some people that that's their business and their profession is we serve court papers. If they're licensed and approved, they can do that. Okay. Once the defendant is served, that starts the clock on the lawsuit. The defendant then has a certain number of days, it's usually 30, to file an answer. That is a written document that looks at the complaint, paragraph by paragraph, and answers paragraph by paragraph. I agree with this, I disagree with this. I dispute this, I don't dispute that. It might say, so if my complaint says from 2020 to 2025, I was an employee of CSU. In their answer, they might say, we agree, that we don't dispute that. In my paragraph where I say I was fired because of my religion, what's their answer going to say? Yeah, we disagree with that, right? If they agree with that, then I'm off to a pretty good start. There's no need really for us to have much litigation, okay? So that's how a lawsuit starts. Filing of the complaint, service of process on the defendant, The defendant then files an answer. Pull up, I have posted a sample complaint for you to look at. This is not on your quiz. It is for illustration only. But this is a sample complaint by a plaintiff who was a customer at a bar, and he got beat up by employees of the bar. So this is his complaint. He filed it in the state court of Fulton County in the state of Georgia. It's all these complaints are going to have the same style. It's going to say what court we're in. It's going to say who the plaintiff is, who the defendant is. So Brett Chance is the plaintiff. The defendant is this Atlanta bar. And the title of this pleading is complaint. So he's going to tell the court, y'all might can scroll down. See how these are divided into paragraphs, 1, 2, 3, 4, 5. That's how all complaints are divided up. We're going to tell the court first about jurisdiction. Plaintiff is a citizen of the state of Georgia. The defendant is a business incorporated in the state of Georgia. It has a registered agent, and that's his address. They've also sued some unidentified individuals that they don't know. They're called John Does. Don't need to worry too much about that. It is possible to sue somebody when you don't know their name yet. You just call them a John Doe, but then later on you have to come in and actually identify them. So then this complaint lays out the facts. Plaintiff was an invitee at the saloon, was well behaved, he paid his bill. As he was leaving, he bought a bottle of tequila to take home. As he exited the bar, employees of the bar assaulted and beat him. He was punched, kicked, stomped, beaten all over his body, He has incurred medical bills in excess of $10,000. He'll have additional ones. He's sustained pain and suffering. Then we get into the legal areas where he says the law's been violated. This section is going to say that the bar is responsible for the acts of its employees. That's the law. Negligence. He's alleging that they violated the law regarding negligence. He's alleging they violated the law regarding assault, battery, infliction of emotional distress. And then we get to the end where this is where he's telling the court what he wants. I want the defendant to be served. I want a jury trial. I want the court to give me a judgment against defendants in excess of $50,000. I want a judgment against them for punitive damages, which is to punish them. I want my attorney's fees paid for. I want my costs and expenses paid for, and anything else the court wants to give me. That's a complaint. Once a complaint is filed, defendant is served, and defendant files an answer, then probably the most important part of the litigation starts. And this has enormous importance for us in our personal and business lives. There is a period that begins after the answer called discovery. Has anybody ever heard of discovery? All right. Discovery is the period of time that each party in the lawsuit gets to collect information, not just from the other side, but from outside sources as well. It usually lasts about 6 months. It could be extended if needed, if the case is real complex, or there are reasons why we need to extend it. 6 months is usually garden variety time for discovery. That is when the parties gather all the information that they can that might be relevant to the trial. Okay? It doesn't mean that we're going to be able to use this at trial. It doesn't mean that everything we get we're going to use at all. But we're doing our due diligence. We're doing our detective work. We're doing our looking into what the other party says. I'll give you some examples in a minute. But there are 3 main methods of discovery that I want you to be aware of. Discovery happens three main ways. One is interrogatories. An interrogatory is a written question sent to the other party that they then have to answer in writing under oath and send back within a certain time period, usually 30, 45 days. I'll give you some concrete examples in a minute. A second form of discovery is a request for documents. That is a written list of documents that you believe the other party has that you want them to give you. The third form of discovery is a deposition. A deposition happens in person. Those first two types that I talked to you about, those happen in writing and they're sent back and forth. Deposition is in person around a conference table where one lawyer is asking questions to the person who's being deposed. This happens under oath and in the presence of a court reporter, so that every question and every answer is being written down, transcribed, and at the end of that deposition, the court reporter will produce a written book. Every word that was said in that deposition. Remember, that's under oath. You don't have to do any discovery. You can do some of the methods of discovery, but not others. You can sequence them however you want. You can go back and do them again if more stuff comes up that you want to ask about. Here's how I might sequence something. I know this is not business law, but a divorce case is conceptually very easy for us to think about when it comes to discovery. If my wife sues me for divorce, her lawyer is going to probably send me some interrogatories first off. That's the written questions that I got to write back answers to under oath. It's going to be things like, list all of your bank accounts. Tell us what bank they're at, what your account number is, what the balance of it is as of today, as of whatever date you answer. Is there anybody else's name on the account, what the account number is, all those type things. List me every email address that you use. List me every social media account that you have and your username. List me every credit card that you have. List me everybody who owes you money. List me everybody that you say knows anything about our marriage that might be a witness. Tell me who they are, where they live, and what it is that you think they know that's important. I'm probably going to do that up front. I get that back, and from that, I'm going to turn around and send, or her lawyer's going to turn around and send a request for documents. And it's going to look something like, for every bank account that you listed, send us the statements. For every retirement account that you have, send us the statements. For every credit card account that you have, send us the statements. If somebody owes you money, send us the evidence that you have, the promissory note. Are there any pictures that you claim are relevant to the case? Are there any social media posts or screenshots that you have that you plan to use? Send me all those documents up front. Then once I've gathered that, then I might decide to take a deposition where her lawyer takes my deposition, let's say. We sit down at the table and their lawyer can ask me any question they want to ask as long as it's somehow relevant to the case. Relevance is a very broad term in litigation, in discovery, I mean. Relevance is a lot narrower inquiry when we get to trial. But in discovery, we're pretty much able to ask and look for whatever information we want. So once we get to that deposition, then her lawyer is going to be able to ask me, well, I see that you have a retirement account with CSU. I see it had $100,000 in there. I see that you withdrew that 4 months before you were served for divorce. Where'd that money go? Why'd you do that? Depositions are real time, right? So whatever answer I give, her lawyer can then follow right up. In the first two methods of discovery we talked about, the written answers and the production documents, I answer that. And then if they want to ask me anything else, then they've got to put it in writing and send that back to me. That's very cumbersome and not efficient. But at that deposition, that lawyer can keep asking me follow-up questions to their heart's content. I did say that you can use these in any sequence, and you can. But you might say, well, why would you even bother with interrogatories? Why wouldn't you just do the deposition and ask all your questions then? The reason you might do interrogatories first is because you could get some basic stuff out of the way. If at my deposition, you're asking me to go through every single account that I have and what the account number is, you know what I'm going to be doing? Pulling it up on my phone, right? Oh, I've got an account at Synovus. It's checking. Here's the number. That's a waste of time. That's something that could be asked in the interrogatory ahead of time, and we get farther down the road. I also could, in the deposition, say something like, I think I had an account at CSU when I worked there, but I can't remember I don't remember how much is in it. But if you ask me that in my interrogatory, I can't say I don't remember how much is in it. I got to figure it out and put it in my answer and send it back. So they each have their own pros and cons and benefits as to what you ask, what you get back, and when you might use them. Does that all make sense? Let's bring it back around to a business law case. In my lawsuit against CSU for employment discrimination, right, I'm going to ask them probably in my interrogatories, list me every single person that played any role in the decision to fire me. Tell me who they are, what role they played. List for me all the reasons that you say I was fired. I can dig into that later in the deposition, but I'd kind of like to nail them down at the very front. I'd like for them to answer under oath all the reasons they fired me. So if they come up with something new later, I'll have something to show that said, well, you didn't say that back then. That impeaches their credibility. In the divorce case, list me all the reasons that you say your marriage is broken. List for me all the things that you claim your spouse did that was misconduct. CSU might ask me, give us all the reasons why you think you were discriminated against. You tell us all the people that you think have knowledge. Why is it that you think you were discriminated against? If in my complaint, I ask for damages, for pain and suffering and mental anguish, they're going to want to ask me where all that comes from. Have you been diagnosed with anything? What doctors did you see? What witnesses do you know that will have any knowledge of how this has affected you? How do you plan to prove that? Those are all fair game questions. Good lawyers do good discovery, and that's where the foundation of their cases are built. Okay? You see a lot of times on TV and in the movies where people are ambushed at trial. That doesn't really happen much in real life. You know, like you got Law and Order and they're like, oh, we just found this witness this morning. If somebody found a witness this morning, the judge would say, well, we're going to take a break. We're going to let the other side interview them. They're going to get to do discovery or depose them or things like that. Okay, we don't just ambush stuff. Lawyers can sometimes play games with discovery, and there's a fine line in that. I'm not going to let my client answer an interrogatory. I'm not going to let them include in their answer something that wasn't asked. Okay? They say, what bank accounts do you have? And my client lists bank accounts and then all this other stuff. We're not answering. That's not what they asked. Okay? If they ask for it, I got to give it to them. I can't play games with that. But I'm not required to give them stuff that they don't ask for. Lawyers can make objections in discovery. Let's say that someone sends me an interrogatory that says, list me all the things. This is in my employment discrimination case against CSU. List me all of the doctors that you've ever seen from age 1 to age 53. I might object to that as not being relevant, right? Or too broad. I could object to an interrogatory that's too vague, that I don't understand, maybe, and ask them to clarify it. Some lawyers will play as much word games as they can and say they don't understand anything you ask and say that everything's irrelevant. If there's a dispute about discovery, you go see the judge, you tell the judge what you asked for, the other side tells the judge why they didn't answer, what their objection is, and the judge will say either you got to give them that or you don't have to give them that. You can get in trouble, obviously, for not turning over the information that you are bound to. Do y'all remember the case? You remember the InfoWars guy, Alex Jones? He had a talk show, but then maybe podcast, and I don't know what he actually does now. But he's the one that said that the Sandy Hook shooting was a hoax. Remember the kids that got shot in the Connecticut elementary school, the Sandy Hook school? And the parents of those victims sued him for defamation. And he refused to give any evidence in discovery. He didn't answer one discovery request. And the judge ended up just going ahead and entering a judgment against him for basically not participating in discovery. He gave the plaintiffs what they were asking for. That's very unusual and pretty extreme, but it did happen. Discovery can also sometimes be limited by finances, resources, right? It may not make sense for me to, if I'm in a case where Will and I get in a fight and I sue him for assault, and I'm alleging that I've incurred like $3,000 in damages. Do I really want to pay my lawyer to do thousands of dollars of discovery? That's a waste of my money. Probably just take my chances and go on to trial and do it there. If I've got a multi-million-dollar claim against CSU, I'm probably going to do as much discovery as I can because the stakes are higher and my resources are maybe greater. Discovery is up to the party and their lawyer to decide what they want to ask for, when they want to ask for it, what kind of discovery they want to give, ask for, and when they want to do it. It's up to them within the discovery period. Now, discovery is not just limited to the parties of a lawsuit. Those parties can ask for information from people who are not parties to the lawsuit. Say in my case against CSU that I sent them interrogatories, name everybody who you say had a decision in my termination. They send me a list of 10 people at CSU who had something to do with it. I can take their depositions. They're not defendants to the case, but I can dang sure send them a deposition subpoena, require them to come sit down in front of my lawyer and answer questions under oath in front of a court reporter. Find out what they know. Witnesses could be deposed. I can send document production requests to third parties. Maybe I don't want to waste time asking. In the divorce case, my wife's lawyer doesn't want to waste time asking me to produce bank statements or credit card statements. They can just send that document request to the credit card company or to my bank. And the bank would have to produce the information. If they want to depose, find out what my doctors know, they could take a deposition of my doctors. They could make a request for my medical records. So third parties, people who aren't parties to the lawsuit, can also be subject to discovery. Has anybody ever gotten a witness subpoena? Anybody ever had to testify in court as a witness? You may, sometime in your lives, get one. It'll say you are commanded to drop everything, all business, and appear before X court and this judge on this date to testify as a witness in this case. You may be like, I don't have anything to say. Still got to go. Okay. In a divorce case, if someone has had an affair with a married person in that married person's divorce case, that person may be a witness. They may be subject to a deposition. They may be called into trial at court. So just because you're not a party to a case doesn't necessarily exempt you from the discovery process. Discovery in the business sense, well, in all sense can be done. We can discover electronic records are discoverable, particularly relevant to us in the business sense. Okay, I might say to CSU in my employment discrimination case, I would like to see every email from 2024 to 2025 between Dr. Finley, my boss, and the dean that mentions my name or that has to do with me. Maybe there are other employees who have been fired for religious reasons. I might want to see those records. I might want to see all those emails. Point being, as an employee and as a private citizen, anything that you memorialize through electronically, through a text, an email, a document you create and store on your computer, a picture you take, a post that you make, all that is potentially discoverable. There's no way for us to know ahead of time what somebody might be interested in seeing later on. We don't know what's going to happen. We don't know who's going to sue who for what. So there's no way to know on the front end what might get discovered. But you do need to know in your professional life and in your personal life the things that you memorialize electronically and store could be discovered in a lawsuit in the future. That should scare all of us a little bit. It shouldn't scare us because it's the way that we live and work. But it should be important to you. It should concern you. You know what? One of the biggest sources of discovery material that I would use when I did divorce cases? What do y'all think it was? Griffin, what is it? Social media. Yeah. Facebook, Snapchat, all those things could be used and used as evidence in court. Maybe less likely in the business sense than in a divorce case, but still. When we talk about career prep, you know that these employers are going to look up your social media footprints before they interview you, right? Y'all know they're going to do that. If I have somebody coming into my office that's a potential client that I've set up a consultation, I look them up. I want to know as much as I can before they come in. That helps me understand the context of what they're saying, helps me understand if what they're telling me is true, helps me understand their case, maybe understand them better. I look up the social media of the party on the other side, right? I get a potential client that comes in my office and says, I want to do an adoption. I want my new husband to adopt my son. I'm going to go look up the biological father, see what all I can see about him. Is what she told me about him true? As far as I can tell, right? Just point being, that's some informal discovery. That's not even discovery as part of litigation. Informal discovery happens all the time. You guys do it. You meet somebody, maybe you got a date, you can look them up. Back to formal discovery in the litigation sense. That takes place in generally the 6 months after the lawsuit is filed and begins. After discovery, then the parties would begin preparing for trial. Trials will happen according to when the judge sets them, but generally they go according to age. You just get in line. When it's your turn to go to trial, you'll go to trial. Sometimes that could be a year, 2 years, 3 years, 4 years later. So you're not guaranteed in a civil case a speedy resolution. Cases get settled. Most cases get settled. Most litigation is settled before it goes to trial. Most litigation is settled without the judge or the jury entering a judgment. Why is that? Sometimes it's possible for the parties just to agree on what should happen. Sometimes people don't want to wait 2-3 years to get their resolution. Sometimes people don't want to pay their lawyers. The longer a case goes, you know who that benefits almost every time? The lawyers. Right? They keep getting paid. So most cases do get settled before they go to trial. Today, part of today's topic is something called alternative dispute resolution. And before I get into that, I forgot to show you our sample interrogatories and our sample deposition. We won't take too long on this, but these are sample interrogatories in an employment discrimination case. There are pages of instructions and definitions. This is to try to keep the lawyers from playing word games in their answers. We get all the way down to the actual, we get all the way down, oh, I think I skipped it. The actual interrogatories, here they are. Identify all persons answering or supplying information used in answering these. Give me the name, telephone number of each person who has knowledge of the facts and circumstances or happenings of the occurrences referred to in the complaint. State in detail, describe all evidence, including documents, affidavits, statements, upon which you tend to rely on. Identify any individuals who had input in the decision to post whatever position. Examples again of interrogatories. You will see in the deposition sample, this is from a divorce case. And this is what the court reporter would generate at the end of the deposition. Every line is numbered, every page is numbered for ease of reference. Q would be question of the lawyer, A would be answer of the person who's being deposed. They're asking in this case about a spouse having sexual relations with somebody they're not married to. And you'll see on page 23 that the lawyer says around line 7, hey, you remember when you answered interrogatories and we asked you in the interrogatories all the people that you'd been with besides your wife or besides your husband, and you said nobody? In fact, they read out your answer. That was sworn to you in June of so-and-so. And the lawyer says, at that point, you had already had sex with Mr. Blank. The answer is yes. Well, why didn't you answer that question the way it was asked? Because I filled that out way before June. When did you fill this out? What you see is that there's real-time question and answer and follow-up in a deposition that you don't get in written interrogatories or answers. Does that make sense? This is just for illustration purposes only. Again, you're not being quizzed on any of these samples of the discovery. I just want you to see how they look in real life. All right, back to alternative dispute resolution. So, Professor, if a majority of cases that get filed end up being settled, how does that work? That works in one of three main ways. The first main way is through negotiation. All right? That is informal. There is nothing stopping any lawyer from calling up the other lawyer and making a settlement offer or putting it in writing. I could file a lawsuit, have the answer, and 30 days later, before I even do any discovery, let's say that I'm the one I represent the person who got sued. I might call up that lawyer on the first day and say, what is it that y'all want? Doesn't mean I'm going to agree to it, right? It might not even be a good deal. But I wouldn't be doing my job if I didn't at least find out, right? Negotiation is not evidence that can be used at trial. It's protected. That's so that the parties can negotiate freely and not worry about at trial a lawyer saying, well, your lawyer offered $50,000 when the case first started. Now you want $3 million. Pretty greedy, right? Negotiations are not admissible. Negotiations could happen, like I said, from the very beginning of the case. As the case progresses, maybe the parties' feelings change. This is a lot more work than I thought. This is costing me more than I thought. I think I'd rather just see what I can settle for. Or this keeps getting better and better for me. My number for settlement keeps going up. The more discovery I do, the better things I'm finding out. The lawyers can still talk about it. They can talk about it up until there have been cases that settled during trial. Maybe something goes really bad for one of the parties at trial and they take a break and they're like, you know what? Is that offer still on the table? Or let me make you a new offer. There have been cases that settle while the jury is deliberating. Maybe both sides aren't real comfortable with how the trial went and they decide to re-engage in negotiations. All that can happen anytime. Maybe I want to negotiate because I want to have some control over the outcome in this way. Now, it does take two to agree, right, in negotiation. But maybe I would much rather negotiate it out than have some stranger judge make a decision just based on what happens at trial and then I'm stuck with it. That might make me nervous. Maybe this judge has a reputation of being very pro-man, pro-woman in a family law case. And I'm going to do everything I can to maybe settle it in a way that I think I can get a better outcome than leaving it up to that judge. Maybe this judge is known as, maybe this judge has been doing this for so long that they understand, that become numb to some facts that might be really bad or sensationalized, say in a medical malpractice case where a child dies. If I'm the family of that child, I think I want to go before a judge and a jury, for sure a jury, where I can play up emotion. The insurance company is going to rather try to settle it if they can, or if it's a judge that has been doing this so long that they're kind of numb to it and they don't get all worked up. They know we're just putting a number to something. Maybe the insurance company likes that out of this judge and I don't. But so there's all these other considerations that go into it. Cost, lawyer skill, timing, resources, relative strength of your case. Olivia.
I have a question. So you know, the law firm Morgan and Morgan,
Yep.
their whole thing is like, if you don't win, you don't charge. Is that like the truth, or like some sort of
So the way that most lawyers are paid by the hour. Certainly any defense lawyers are. But a lot of plaintiffs' lawyers in personal injury cases will be paid on a percentage basis of what you recover. So that is, a lot of personal injury lawyers will do, you don't win, we don't get paid. The flip side of that is, if you do win, they get paid like 40%. That is good for a plaintiff who doesn't have any resources, like I can't afford to pay a lawyer. It's bad for that person who then wins a multi-million-dollar verdict and has to fork over 40% of that to the lawyers. The lawyers are doing the same amount of work, no matter if the verdict is 1 million or 100 million. But they are taking the risk of getting nothing. So that's the trade-off. That is all negotiated out in the front. You go to Morgan & Morgan and they say our fee is 40% and you don't pay if we lose. You could negotiate that. If you're like, I would do it for 25%, they could say okay, or they could say no. All that is negotiable between the people. Will. So it is illegal to do divorce cases by contingency fee. Yep. Because they don't want lawyers to have a personal stake in the outcome of best interests of children and families. You still, I know Georgia doesn't allow it. Georgia doesn't allow it. Mostly it's personal injury cases. And if the lawyers are saying, well, I'm taking some risk, I'll take your case. We may not get paid. And if we don't get paid, I'm out all the time and expenses. Maybe we depose these expert witnesses. We flew around the country to do these depositions. We lost that case. That's just, the lawyer eats the cost. The trade-off is we win the case. I'm going to take more than I might have gotten if I was just paid by the hour. But yeah, that's a question to ask any lawyer you hire. What's the fee structure? How does that work? And is there any way that we can do it differently if you want to? Will. Corporate lawyers generally are earning their fees by the hour. It's usually just personal injury lawyers that do the contingency fees. That's a great question. So negotiation is one way that cases get settled. Another way that cases get settled is through mediation. Mediation is required by pretty much every court in civil cases. Mediation is done like this. It doesn't involve the court, but it involves a neutral mediator that is selected by the parties, or if they can't agree, the court might appoint one. The mediator is usually a lawyer, but doesn't have to be a lawyer. It could be a person with a certain expertise in that area of the law, or that's expertise in a certain dispute. The mediator is not on anybody's side. The mediator makes no decisions, rulings, judgments. The mediator's job is just to go back and forth between the parties and see if he or she can facilitate the negotiations for a settlement. The parties come together. Before COVID, we always came together physically in the same place. And one party would be in one room in the building, the other party would be in a different room in the same building. Mediator goes back and forth. Nowadays, a lot of mediation is by Zoom because we can be in virtual rooms. I think it's more effective in person, but I do understand why, from a convenience perspective, a lot of lawyers and parties would rather do it by Zoom. But the mediator is just in charge of conducting negotiations. If the case does settle, then that gets put in writing. Everybody signs off. This is what we agreed to, and we're bound by that. If the case doesn't settle, then that's the end of it, and the parties can continue on down the road to trial. The mediator can't be called as a witness. Can't say, Mr. Mediator, what did so-and-so offer? What did they reveal to you? The mediator is completely immune from that. In my experience, mediation settled a lot of cases. Also, in my experience, the cases that didn't settle at mediation ended up settling based on the groundwork that was laid in mediation. So take a divorce case, for example. Let's say that I've got a divorce case and the issues are custody of the children, child support, alimony, splitting up retirement accounts, splitting up the house, visitation over holidays, right? We might spend 4 or 5 hours at mediation and we might agree on custody, visitation, child support, but we don't agree on alimony or division of bank accounts. There's nothing stopping the lawyers after mediation but before trial from picking up the phone or writing a letter and saying, okay, we're going to make you another offer on alimony or on division of the marital house. They can respond. You can keep negotiating. There's nothing stopping the parties from going to trial and telling the judge, we've agreed on these areas. We're down to alimony and division of assets. So we just need the court to hear those issues. Now, if you agree on everything at mediation, you're done. If you don't agree on everything at mediation, you haven't formally agreed on anything. I'm just saying that very often the lawyers will take the work that you did at mediation and build off that. Okay? Mediation is helpful in so many ways. Before we go to trial, if I don't have an offer from the other side, I can't really advise my client on the risks of going to trial, what's most likely to happen to go to trial, to weigh that against the offer that they have in hand. I'd love to have an offer so I can say, okay, you could settle it now for this. You guarantee this. If we go to trial, you could get more, you could get less. Here are the reasons that I think you might get more. Here are the reasons I think you might get less. Here are the strengths of our case. Here are the weaknesses of our case. If we go to trial, it's going to cost you this much more because it's going to be this many more hours at least of my time. If we decide to go to trial and turn down the offer, that may be a year from now. Are you willing to wait another year to potentially get more, risk getting less, or would you rather take what you have now? So mediation at least finally gives you an offer from the other side that you can then use to evaluate your strategy going forward. It also gives you some insight as to why the other party's asking for what they're asking. There's nothing stopping me from asking the mediator, hey, I know that let's go back to my employment case. Business cases are a lot less, there are often less issues in mediation in a business litigation case. Why is that? It's usually just about the money, right? I got fired from CSU. What do I want? Money and maybe my old job back. We ain't got to talk about who's visiting the kids on Christmas Eve and spring break and Easter. Here's my number. Here's your number. We're going to work off that. In a car accident case, here's my number that I want to pay me for everything that happened. Here's the insurance company's number. Very much more focused than maybe a family law case. But I might be able to ask the mediator, okay, well, I see that CSU's only offering me $20,000. I think I'm entitled to $4 million. What are the reasons behind them only wanting to offer 20? And the mediator can say, and then the mediator cannot reveal anything that the other side tells them in confidence. But the mediator, if the other side is fine with it, can say, well, they think their case is strong. You did this, this, and this. Their evidence shows this and this. That helps me advise my client, okay, well, this is why they think this. And to ourselves, we might be like, great. That's exactly what we want them to think. They don't know, or, our cases, we're each seeing our case differently. We're valuing our case differently. But it could also be a situation where the mediator says, well, Mr. Tebow, help me understand why you're asking for $5 million. Your client, you were only employed at CSU for one semester. You already have another job that pays more. How do you think a judge or a jury is going to give you $5 million? And it's a good wake-up call for some parties. Like in my, I know I keep going back to family law because I have experience, but also because I think it's just easy, it's conceptually easy to understand. If I have a client in a divorce case and he wants $7 million from his soon-to-be ex-wife, and she's been a stay-at-home mom for 30 years of marriage and doesn't have a job and doesn't have $7 million, then the mediator is going to say, Mr. Tebow, what judge is going to award your client $7 million from a party who doesn't even have $7? And it's good for clients to hear that. Because a lot of times our clients are like, I want blood. I want you to rip their heart out and take bites of it, right? I would always say that, then you got the wrong lawyer. That's not how any of this works. Okay, but point being that clients, their demands and their positions can be influenced by emotion and passions and things that aren't necessarily going to be relevant to the judge or the jury. And a mediator can help point that out. So that's how mediation works. A third method of alternative dispute resolution is arbitration. Arbitration is when the parties submit their case to an independent, neutral arbitrator, kind of like a mediator. The difference is the arbitrator will hear evidence, have testimony from witnesses, and the arbitrator will actually make a decision. The arbitrator is not a judge. We're not in the courtroom. It's like a trial. You can't be forced to arbitrate if you don't want to, unless you've agreed to it in a contract. I guarantee you that every one of us in here are subject to a binding arbitration agreement from some user agreement we've entered into. We click agree to the terms, right? Anybody read the terms? I don't read the terms. In most of those types of contracts, we're agreeing that if a dispute arises out of this contract, that we're agreeing that it's going to go to arbitration and not court. That might be fine, but it might not be fine. So you need to pay attention, maybe not so much in your, user agreements on apps and stuff, but in business for sure. In the contracts that you sign, you need to make sure that if you're agreeing that you only go to arbitration, that you're okay with that. What are some reasons why why are all these businesses, these app developers, these companies, why are they all trying to trap you into going to arbitration instead of suing them? Why do you think? Quicker, yeah, and less costly for them, right? They would rather go to an arbitrator, get it over with, not go through this discovery phase and wait on the judge's calendar to open up for them to do this in 3 years, pay all these lawyer fees. They'd rather get it done. Just tell us right up front if we owe money or not. The arbitrator is also less likely to be moved by emotion, right? If I have that medical malpractice case where I really want the jury to punish this doctor for what they did, an arbitrator who hears medical malpractice cases all the time is much less likely to make decisions based on emotion or how bad everything was. I might want to submit my case to arbitration. Let's say that we don't have a binding arbitration clause, but I talked to the other lawyer and I'm like, hey, let's arbitrate this. And the other lawyer says, that's a great idea. We might want to do that because we might want to pick an arbitrator that has expertise in the subject matter of our lawsuit. say that CSU wants to sue the construction company that built this building and screwed up whatever it is that they've been fixing for the last 2 years. Okay? CSU could sue them in a court in Columbus and go in front of a jury of 12 citizens from the area, probably none of whom understand anything about construction. We could allow the judge to hear it, and that judge could be a judge who knows nothing about construction. Or we could pick an arbitrator who's very well known in the construction industry for handling construction cases. That saves us from having to explain everything, right? The arbitrator already understands what blueprints are and what work orders are and all these things. We're not relying on the jury who might have no expertise. So arbitration can help in that area as well. So those are the main forms of alternative dispute resolution: negotiation, mediation, and arbitration. I do kind of want you to know the differences in them and the pros and cons of each as they're laid out in your outline. On Thursday, we will talk about the Arrow case, so please read that. I'm going to ask you, now I know your name, so I'll be able to ask you details about that case. And then just read the fact pattern on the slip and fall. It's very short. You can read that right when you come to class and sit down while I'm taking roll. But we're going to discuss those things. And then if there are any questions that y'all have about anything in Unit 3, we'll take up that as well. Will. So if the parties choose to arbitrate, they can choose the arbitrator. Or they could say, Judge, we can't agree on an arbitrator. Here's our list. Here's their list. You pick. But if there's a binding arbitration clause in a contract, then it's going to spell out how that's chosen. You don't even have a lawsuit. There ain't no judge involved. You're picking an arbitrator. And maybe if you can't agree on one, but the contract will say how it's chosen. Yeah, same thing would happen in a divorce. We'd submit, and we didn't arbitrate a lot of cases, but we did arbitrate some where like the one I'm thinking of was I represented a doctor. The couple had a lot of assets. It was very complex. We got assigned to a judge that nobody liked, that we didn't trust to follow along some of the complex stuff. And me and the other lawyer was like, let's get an arbitrator. We both picked one that we'd used before, we were familiar with, that we thought would be fair. And instead of submitting it to this judge who was very hard to get a trial date from and that we didn't trust anyway, we were able to get somebody that knew exactly what they were doing to come down and do it. You ready to do your part? Come down here and grab the mic. Anybody have any questions while Will is coming down? He's going to talk about the GroupMe that he created for y'all, and of which I'm not a part of, so that's intentional. Go ahead. Say whatever you want to say.
What's up? So I set up the GroupMe. It's just a free resource for you guys. I'm going to be posting like the lectures, slides, career fair updates, all the CSU events, and links to like his YouTube channels up there. Just so many of you guys have joined already. Just like make sure you check out the main introduction in the group chat and just look at those terms and conditions. There aren't many. But so this semester I'm going to be posting like, job opportunities on Handshake, Career Center, reminding about the upcoming project, which is due April 10th, I believe. And just updates like that. So like this afternoon, I'll post like the link to the YouTube video and some other stuff. And I'm also going to include like a section where we can post about like our internships and like interviews and things that we've learned in our interviews so we can help each other out. Like I'm really just trying to create like a little community here where we can help each other out and grow, because there are a lot of available resources to us. And I feel like we should take the university up on those opportunities. You don't have to join, but if you'd like to, that would be great. We would love to have you. Almost 20 of you guys have joined already, so thank you guys so much for that. And if you have any questions about it, just shoot me a DM. My DMs are always open. So yeah, thanks guys.
The QR code is posted in the thing. Again, I'm trying to say this right. I think that's a great resource. I'm not requiring you to do it. I'm not putting any content on there that you're required to know for quizzes. But I don't want you to interpret that as me being against it. I think if that's something y'all want to do and it helps you, go for it. But I don't want you to use it as a substitute for reading my announcements and looking at the course content and all that kind of thing. All right, if nobody else has any other questions, I'll see y'all on Thursday. Thank you, Will.